transactions, ones that was in effect applicably and ones that is permitted by the U.S. government, which is why in each one of them, no matter if you're there on Visa, MasterCard, or American Express, they're going to tell you that they're government mandated or the wholesale rate standard. Let's talk about it. And then it's another agreement that'll go with it for this new honored presentation that's permitted now. And it'll be used for the future because everything that it, or let's just say because of rights, not remedy. They'll get remedy after rights. That leaves you without recourse, allowing for them to do it all. And money will be paid. Restitution. Not that you pay, it's somebody else gonna do it. Who owe y'all restitution? This is gonna pay for any discrepancies or concerns when state law, applying to your document. Tender requires more documents be added so that the face be fixed and signed by the person who actually is presenting the document. You're not presenting it. It just was issued, transferred to you, transported to you. Sometimes it's forwarded to you. But it's really because fraud and forgery. So if y'all sign it too, so many people get back fraud letters. It's because of what they just said. What they just said about the issuer. What they just said about the extent of discharge and performance and what's apparent on his face and who's actually concerned with the discrepancies. So they may be like, yeah, you fraud. You shouldn't have did that. Now you put me in a risky transaction. I can't legally negotiate this if your signature on it and it's incorrect at that. How y'all feel? What's your thoughts?
My thoughts there is I need to go ahead and let the issuers, it's not representative, but I got the new term that they just introduced, let them go ahead and fix my signature on there.
Yeah,
But
you
that,
just have to go ahead and let the advisor see the instructions on what the terms is for setting that signature. Once they do that, the issuer has something new, and now the issuer is able to take that document as a beneficiary to its bank.
and so if we affix a price on the front of, say we see an open term, we decide we want to do our own math or whatever, and we put a price that's just way out of the range or way below, that's essentially fraud. Essentially fraud for them because they can't issue that back to the issuer to be able to be used in any transaction because of
Exactly.
the amount. Okay.
It's inoperative.
But
Things are
Kamaya,
done operation of law. So use the law to operate the document. Use their forged unauthorized signature to better yourself or a situation for the issuer so that you stop fraud. So all Article 1 talking about common law principles, stopping fraud, stopping mistake, coercion, and valid documents, law of merchants, equity. You talk about that. It's material things.
so Kamaya, let's say like what Jared was talking about. Say we present the wrong amount on that. Can't we allow them to fix that? Like you say, we don't do the math, right? And our math may be off. So, like, say if we present the wrong amount, can't we give them the right to go in and fix it and
That's
pass
what
it
you
on?
was. I mean, only after they present you another notice. But that means you're just gonna repeating the same action all over again, trying to give them the right to go ahead and do it. If you mess it up, it's undetermined on what you was trying to do, period. Your intent ain't there for me. I don't see it in no way. So I don't know what to correct. I don't know what the problem was. So your discrepancy is a little bit more conditioned to that policy than them making a mistake. If they make the mistake, they're gonna retract it and correct it. That's the purpose of them sending you the bill for those mistakes. So you can't, they're not gonna call you and say, hey, you put the wrong amount on there. They're gonna tell you in your next notice. And then it gives you the opportunity to do it then. You either correct your mistake then, either using the notice that they gave you or a substitute, or you ask them to correct whatever mistakes may be. Because you don't have the knowledge of the mistakes, but you observe that there is a mistake. So with commercial knowledge, what's mistaken? Whatever is mistaken, let's see what we can do about it. But something is definitely mistaken. And it's the signature. How you feel? It could be an innocent misrepresentation, but it ain't gonna allow for them to correct your mistake. They can't cross your signature out and then put their own. They can't recreate a document when that document came from purchases you already made. Things that was done in the past you can't go back there and change it. You can just start new from that point. And if you use that spot, it ain't no new point for them to start from. How you feel? You get it?
That makes sense, and that's why we have to leave it blank and we're not supposed to touch it. This just explains it in a lot more depth.
You with it?
Which
Absolutely.
So fraud and forgery. If a presentation is made that appears on its face strictly to comply with the terms and conditions of the letter and credit, but a required document is forged or materially fraudulent because you forged your signature on that document and that wasn't even a condition to the term that you had to do it. Or on our other presentation will facilitate a material fraud by the beneficiary on the issuer or the applicant. Now they list out a few things too. But before we even get to those things, they have to furnish suitable facilities, suitable receipts. You received a receipt that wasn't suitable. So they will facilitate an international trade transaction where whatever was materially fraudulent, whatever was forged, whatever was incorrect, whatever was mistaken, they will comply with terms that will strictly allow for them to apply another term in that spot and the amount due to meet the condition of a letter of credit. You don't have to do it. You're not the borrower, so you may not even be the applicant, or you won't be the last one with it because it'll change. Titles will change. They're talking about issuer or applicant here because of issuer, applicant, and who else they talk about? The advisor. How y'all feel? What y'all thought? It's a requirement that the document is forged. It is required that there is materially fraudulent information when you receive it, giving you the opportunity to comply with other terms so that you could furnish a facility, you can furnish a receipt that is suitable for customary practices. So there's some material fraud. If you fill out that spot, it could be material fraud because you materially affected a spot that is used to help meet and comply with the terms of the letter of credit.
That's crazy. So regardless, they can still utilize the document.
And yeah, for them in one way, just because you did something messed up. Oh yeah, it gives them the chance to use it without your say so, whether you know it or not. Yeah, it allows them to do them and collect from you at the same time. Because what's deposited has already been deposited. They holding it at a disposition. So yeah, they get to continue on, all because you committed material fraud. Now you get no benefit.
Right, but they still benefit.
Yep, because of forgery. Mm-hmm. When all along they was the ones with the forged signature. All along, but we took it upon ourselves to correct it. That's when Navy Federal talking about when they said and they updated that agreement and they put we rely on information for the payment networks. So for any person who want to sign right there and do it wrong, they're gonna close their account down. They're gonna call them fraud, and they got every right to, because in good faith they'll do it for them.
Is their forgery the amount that they put on top of the document so that new balance or not new balance, but whatever that balance is down at the bottom before above the open box? Is that what they forged? Is the signature?
Yeah, all the symbols, all the time. Okay. Yeah, it's all forged so that they could be able to utilize the document in a transaction. It's just that the transaction was an illegal transaction.
So that new balance and that minimum payment, they just putting up on that document.
Posting shit to account.
And that's why it becomes a new document.
Exactly. So that spot is left open there for a party to benefit or parties to benefit. It's necessary. They told us that in Article 2. It's necessary and relevant for that spot to be apparently missing on your face so that Amex, Visa, MasterCard, they can all discover a new rate, another term, another condition for a letter of credit instead of just your letter that may have some mistakes or discrepancies in it or potential errors in it. It's a required document for something else.
And so then that new document that they have is now like, it's not fraud, it's not forged because they created it.
Right. It's a receipt that is suitably furnished for deposit, to be issued, to be received, to be used, to be honored. Now he's talking about demands. He talked about document, statement, demand, advice, all in one whop. Now he's talking about demand. Using a document. Paying attention to and observing its face. Which I got as a preface. When it reveals itself, then they can use that exact same face to use it to another account, one that they own, their own. They're using the exact same document for its own account. You will see a lot of times they tell you, if I advertise to you a document that I own, because it's theirs, right along with the account, and it goes for it. It's just that, because they signed it, it can't go in there yet. It'll be fraud. So due to contracting, this is how they stop fraud. Having another person sign it in agreement that we're forming a contract with each other for a new transaction that's in compliance with new or additional terms and conditions. One particularly of a letter of credit. So they give two cases, things that the issuer shall do. And then even within the first, there's 3, 4. So the issuer shall and must honor the presentation if honor is demanded by a nominated person who has given value in good faith and without notice of forgery or material fraud, or they must give value in good faith to a confirmer who has honored its confirmation in good faith. Are you confirming good faith? Are you getting clarity on what good faith is and what that would mean for a merchant? Somebody could confirm that and get advice from another person to stop material fraud, to stop forgery, to stop illegal use. They'll do it in good faith. They'll give more value to the document. 3, a holder in due course. A holder in due course, Aaron. This is the 1-303 you're speaking about. A holder in due course of a draft drawn under a letter of credit, which was taken after acceptance by the issuer or nominated person. Who's accepting the document? An issuer or a nominated person? There's going to be a nominated person who's going to send back to the issuer a request that you are considering transacting in another way. And that issuer will be the one who will honor that presentment because it's demanded that they give value. Whether they have to sign to get it over to another person, or whether it's already assigned and now they have the ability of an assignee to give an assignment to another. Someone who the issuer has nominated or who the nominated person has deferred the obligation to. Now, a nominated person deferred the obligation to you. However, the obligation and rights should be assigned to issuers. You can fall into either or category. So it's up to you to see to it that any deferred payment or any payment you get, that it was taken for value or it is taken for value or without notice of forgery or material fraud after the obligation was incurred by the issuer or nominated person. So when you get your bill and you get your notice, so many people are utilizing it and deferring payment without noticing that there's forgery or material fraud. Now, if you send it back to them and you sign in their spot, they gonna notice that there's forgery and material fraud, but you may not notice that. But in the case that you do notice that, then they'll be able to use the draft and they'll be able to utilize it under a letter of credit, performing acceptance. This happens after somebody requests or say something about something. That's the only thing that's going to make the issuer honor anything. So 2, not only is the issuer going to be honored, the issuer also is acting in good faith, just as a merchant. The issuer, acting in good faith, may honor or dishonor the presentation in any other case. So in the case of dealing with you, they dishonored the presentation. They didn't do it. But in another case, in an appropriate case, that same issuer can act in good faith and they may honor a presentation and accept it in good faith under a letter of credit. That means that they are applying permitted laws, bankruptcy laws. So you will never not kind of see that mentioned, even though you know you didn't file for bankruptcy. How y'all feel? What's your thoughts? The issuer.
Is that bankruptcy notice that's on the back of a bill important to us as far as the initial steps of getting the issuer to be able to
It's,
take action, a new
it's
action
important to them.
for
That's
them?
why it's
Okay.
there. Because those are laws that they will act and follow in order for them to act in good faith to confirm credit. It's bankruptcy laws, not you.
Okay.
But it's there so that you can see that this is the applicable or permitted laws that they're going to act under, along with being responsible for the Fair Credit Billing Act and the Military Services Act, as they accept in good faith your item, your document, your presentation. How y'all feel? Or a presentation, not yours, but just a.
I had to touch on the suggestion by you to just simply reject. This gives us the background for it, but we are still not supposed to be bringing any of this up to them, correct?
They will reject. It's already there. They already know. You can mention it and get information or advice on the rejection, but it's already there for them to reject. Whatever you see, already there, already could be done. A claim for it just has not yet been made.
Okay. Yeah, this is great. I love this.
If an applicant claims that a required document is forged or materially fraudulent, or that honor of the presentation will facilitate a material fraud by the beneficiary on the issuer or the applicant, a court of competent jurisdiction may temporarily or permanently enjoin the issuer from honoring a presentation or grant similar relief against the issuer so that they can enjoy permanently or other persons only if the court finds that. And then it's about four things that they need to find. But before we get into what they need to find, do y'all understand what they just said? This is going to explain temporary credits, permanent credit, the facility that was used, honor.
So is this speaking to like a provisional payment until an investigation is?
That and just things that you can actually request. You can request that the issuer permanently enjoy the item by honoring.
Okay.
So plenty of things that they said you can request in here. It'll get similar relief. Y'all want relief? Granted relief to the issuer. Act how you want to act. Have good faith.
Ooh, I like that. You just said grant relief to the issuer, so we are the God grant relief to somebody.
So that they can act, facilitate, stop fraud.
So maybe federal was in line. This transaction really ain't between them.
It's not. It's another creditor. And
Yes.
that's exactly what they're talking about with balance transfers. Yes, there is a balance transfer, but do you know that there's another balance transfer that's not with the creditor, Navy Federal? That's exactly what they said right here. They said it. When it comes to balance transfer, I had somebody try to tell me what a balance transfer was. When I know they know of a balance transfer. It depends on your route of relief. That's what the court finds. That's what the individual who is aiding and going along with finds to be necessary or finds to be a part of their belief system. The relief is not prohibited under the law applicable to an accepted draft or deferred obligation incurred by the issuer. whether it's a payment or a draft. Release is not prohibited under law for the issuer, regardless of what they did. They're going to get relief too. Yeah, they may have made a mistake. Yeah, it may have been potential error. But in the same token, they are forgiven too. A beneficiary, issuer, or nominated person who may be adversely affected is adequately protected against loss that it may suffer because of the relief is granted. So when relief is granted, subsequently, you're protected as well. Although you see the Military Lending Act, although you see the Fair Credit Billing Act, although we can read all those acts, we're just adequately protected as the issuer, the beneficiary, or nominated person acts under those acts. It's for adverse action. All of the conditions to entitle a person to the relief under the law of this state have been met. So under the state of Virginia, like they just said, all of the relief that they need has already been met. All of the conditions for them has already been met. It's already been done. So if it's already been done for them and you under the state, has already been done for you. So the person who is actually entitled to the payment or entitled to the incur or defer obligation needs to receive it. And on the basis of the information submitted to the court. That's the only way they can receive it, by information. Y'all can do any numbers and any math y'all want. Information, important information. The applicant is more likely than not to succeed if they have information under its claim of forgery or material fraud. And the person demanding honor does not qualify for protection under subsection A1 if it isn't any type of reason for material fraud or forgery claim. I wrote them a letter, let them know it was materially affected. Talk about material defects. They rely on information. Information is what's going to grant relief. If you don't have any information or nothing to say because you haven't read it or you don't understand it, then you're going to have a hard time expressing conditions that another person is entitled, or even terms that another person is entitled to. It's just about information. On the basis of information, we transact and we have good faith. So what you say, how you say it, how you act, it determines everything about you. Each and every time they act, it don't matter if they acting in the way you want them to or not. They're going to have good faith. The way that they acting is going to be according to what you say. And what they say back is going to be in good faith. That means that you should listen. Because that person is entitled to something and some sort of relief that you're not expressing. How y'all feel? Warranties.
Okay, so I was thinking of relief as insurance.
It will be for them. That's their relief because they got the insurance policy. That's the purpose of us transacting with them so that they can utilize the insurance policy for this relief. We
Yeah.
get relief by asking for it.
Well, exactly. That's how I'm thinking of it in the two ways. Like, again, we can reference Navy Federal because they're the most straightforward when they talk about a notice of a claim and how they need information so that they can create a claim.
All of them will say it though. All of them will talk about notice of claims, and all of them will talk about warranties and transferability and merchantability and mistakes and error. They all talking about it so that they can examine the document to see what truly is mistaken and can take corrective action. That's what that notice of claim is about. The difference is, like I keep saying, people is focused on interest and fees being missing. That's not the warranty given to you. It's warranty given to you about interest and fees that it will be included, it will be added, it has been subtracted. You get those warranties. But that's not causing a discrepancy. Anytime somebody calls them, they say it's already there. It's already added. The interest was there. Interest was this. That's not what they looking for. They examine the document for something else.
These discrepancies are monetary discrepancies or value discrepancies on the document.
Material discrepancies on the document. How y'all feel about warranties? I know I said enough, but what warranties come into y'all mind?
What they gonna do, what we gonna do, how we gonna
So,
act.
so implied and expressed.
Hmm.
Things that is implied, and then there are some things that need to be expressed. That's what the whole 9, 8, and 7 was talking about. Things that should be expressed that maybe wasn't expressed. The issuer has the option to work in one or other way, or they can work one of one or two of them, two. It's a choice, just like with the application or any agreement. It's part one of two, and then they go to two of two, depending on if that issuer is actually following the provisions of the rest of the agreement. How y'all feel?
So you saying the issuer may just start following part one, but not follow part two of that agreement?
It will follow it, but for them, because they deal with things yearly, you deal with things monthly.
Okay.
They give you warranties of that, where they give you APR, where they say
Hmm.
yearly, where they say monthly. Those are warranties.
That's what we must abide by. Or that's what the issuer needs to be abiding by on a monthly
Right,
basis.
right. And some of
They,
those warranties that are implied, they are indeed abiding by because of the state. The ones that they are not abiding by because of the state are the ones that is not expressed
so
because it
usually
hasn't
when
been expressed
then,
yet. Right. That's what happens now for the future.
so like when you see the I think minimum interest payment or something like that, or minimum interest charge or something like that, if it says none, that's not
That's a
implied.
discrepancy for them. That's
Okay.
implied. That is not there. So
Mm,
express would be them seeing the discrepancy with that and expressing it that is there, and you should see some interest charges
got you. Okay.
about that. It ain't about no fees. That's for something else. So warranties is important. Warranties is the main thing that got people confused or saying they didn't say this or I didn't know this or I thought that it's the warranties that's given. What needs to go with the warranties that you see that has already been done or is in the plan to be done? What's the discrepancies in and what's stopping it? It might be you, or it might be the payment, or it might be both of y'all. So warranties about it. Warranties about the document. If its presentation is honored, so it in whatever form it is in is not going to be honored. Only if it's in a presentation that it could be honored, will it be honored? That means that a furnished facility was actually given for its purpose, for its own, the issuer's own account. If it's not suitable for that, they can't use it for presentation to its own account. It has to go to somebody else. So now you get an account every month. If its presentation is honored, the beneficiary warrants to the issuer any other person to whom presentation is made and to the applicant that there is no fraud or forgery of the kind described in section 5-109A, which is in the past. So if your presentation is honored by them, then the issuer is saying, or it warrants, or the beneficiary warrants to the issuer, the applicant, that there is no fraud or forgery. And they warrant to the applicant that the drawing does not violate any agreement between the applicant and the beneficiary. That agreement that y'all read, you should never feel involved in it for a lot of reasons. Because there's other agreements, any agreements that's between applicants and beneficiaries, and other agreements that's intended by them to be augmented by the letter of credit. However, if you don't, or they don't have reasons to intend to actualize or to bring forth that other agreement, then it's just not going to happen. But it has to only happen by way of that letter of credit. So that letter of credit is intended to activate another agreement between the beneficiary and the applicant that will allow for no forgery and fraud to happen. Each and every time you get your notice and it has not been honored just yet, it's giving you the fair opportunity to request or ask that an applicant utilizes another agreement under a letter of credit. The warranties in subsection A, they are in addition. They are in addition They are added to warranties, the same warranties that might be implied, and the warranties that is arising under Article 3, where people think they got a negotiable instrument, warranties under Article 4, where people think that they the ones who collecting and depositing, or even those who feel like they the bank. Article 7, for anybody who think that they have a bill of lading or a warehouse receipt. And Article 8, for anybody who believes that they dealing with investment securities. For any reason, I don't even care if it's for insurance. It's not for you yet, or as of now or in the future. It's because of the presentation. What you simply have, or transfer of documents that's covered by any of those articles. So if you're transferring your documents to be covered by those articles, none of those articles has happened yet. 3, 4, 7, or 8. Can't even think about it. Or you shouldn't. And that's just my opinion. But they said it. It's because of the warranties that I see and I pick up, and I see things that could happen. You have to eliminate certain articles. This is what allows them to choose applicable law in different situations. One situation may include it 1, 2, 5, 6, and 9. Another transaction may include 1, 3, 4, 7, and 8. Two different situations dealing with the presentation itself. Just depends on what it is at whatever time any person is dealing with it. How y'all feel?
Good. I feel like this section is basically telling us that we need to put them on notice about the warranties. Otherwise, the document can't transform.
Right. They're waiting for an express agreement. Any other agreement that is intended for them to carry out a letter of credit. They're waiting for somebody to express in addition to any other warranties that was already given. Under Article 3, like people seeing negotiable instruments and taking it to heart. Or Article 4, people may see deposit account, credit account, asset account, and they take it to heart. These are just warranties in addition to things that you express once you actually discover and learn why you got your notice. They'll pick up the warranty that, okay, you want to use this document so that it can be honored for presentation. Or you want the issuer to present this document in another way. They're going to pick up on the warranty by the things that you say, by the messages that you write, by the, what did you say? What you say determines the law that they choose at that time. So this is why knowing your rights and the law is more important than anything legally will ever be, in my opinion. Because remember, they said opinion, advice, all that good stuff. The only way you can have any of that is if you give information about it. How you feel? They get remedies if you do. You will never get that. Ever.
This is probably my favorite article so far.
Why?
I don't know, because it's just like, to me, this seems like this is where the meat is. Maybe it's more relevant to the stuff that you taught us in Houston, and this is really kind of the aha as to it's just telling us like what they're doing and really where our claims are. It's just much more clear to me now, having seen even the parts that I missed. I mean, I only missed an hour and a half, but just the parts that I came in to see, it's a lot more clear to me now. I just think it's a very powerful article.
It's telling for sure.
Yeah.
The exact same document y'all got, they want to use again. They just gonna add other documents to it, and they're gonna deposit it into their own account. Unless you got a financial institution account you want to use. And if you use it, that means you taking your own funds from it. If they use their own, that means they taking their own funds from it. And then they'll deposit into a financial institution account, just like it's instructed on the bill that you will see. Warranties about what could happen from one account to another account, person to person transaction. With the exact same person, using the exact same instrument, just receiving it from different people at different times, from time to time. So remedies. If an issuer, not if an individual, I ain't even talk about a person. If an issuer wrongfully dishonors or repudiates or rejects its obligation to pay money under a letter of credit before presentation, you ain't never supposed to pay. If you feel like that, you can. But The obligation to pay is of the issuer. If they wrongfully dishonor and don't pay and reject it to you, then it's some stuff that needs to happen. But before that, they wasn't acting under a letter of credit. They was acting under money that needs to be paid. Like they mentioned a few articles back. That was in a different transaction. So if an issuer wrongfully dishonors or rejects or repudiates its obligation to pay money under a letter of credit before presentation, the beneficiary, the successor, or the nominated person presenting on its own behalf may recover from the issuer the amount. And not saying they got to recover from the person the amount, from the individual the amount, but on the individual's behalf or on a person's behalf, they may recover from the issuer the amount that is subject to the dishonor or the rejection for the face of the document. It'll be apparent that that's where it should go, right there. If the issuer's obligation under the letter of credit is not for the payment of money, the claimant may obtain specific performance or at the claimant's election. So the claimant has the choice. You're not the claimant. The claimant has a choice to either not use the letter of credit and use it as a form of payment, or they have the option to obtain specific performance, specific advice, specific instructions, specific terms, and elect that. They have choices. So that they can either recover the amount or recover an amount equal to the value of performance from the issuer. So you either can pay exactly how much it costs, or you can pay a little bit more, or you can pay a little bit less. The claimant can recover either way it go. You're not the claimant. In either case, the claimant may also recover incidental but not consequential damages. Those two types of damages that a claimant is dealing with. In one case, they're dealing with incidental damages, and in another case, they're dealing with consequential damages. In the case that they switch from seller to buyer, that's what allows for them to have remedies. So this is why in all your agreements they talk about seller and buyer, and you may even see remedies giving you the warranty that they can take action for damages, whether it's incidental or consequential. But I cannot express that to you one way or the other. I give you no warranties about it because it don't have nothing to do with you. But you can express what you see. And then I can follow another agreement. Your express agreement plus an agreement that I know I got with another person. But up until then, I'm not. The claimant is not obligated to take action to avoid damages that might be due from the issuer under the subsection. It's only if you request. So they have a section in all your agreements talking about avoiding interest. If, although not obligated to do so, the claimant avoids damages, the claimant's recovery from the issuer, it must be reduced by the amount of the damages avoided. So a lot of people talking about interest that they got, they're giving you a reduced amount from the issuer. It must have been reduced because they had a claim to recover something. So as long as they have a claim to recover, they will. They can either recover the amount or they can recover an amount, a amount, the amount, different amounts for damages. The issuer has the burden of proving the amount of damages avoided, whether it's there or not, whatever was avoided. The burden is on the issuer to prove the amount, unless somebody else who's issuing it thinks that they could prove the amount. In the case of rejection or repudiation, the claimant need not to present any document. You don't have to present a document. You don't have to present a document. I use my stuff every month when I present one. But one is presented to me, or one is delivered or transferred to me. Or I'm putting on notice, but it don't have to be moved. They just want a document. And with that document, they'll add additional documents proving the amount of damages. Insurance, they'll cover you. They have insurance policy. They'll have the right, whenever the issuer wrongfully dishonored or rejected an opportunity to make payment. How y'all feel?
And this would be the seller would be.
Yep. Yep. So that's why you need that original seller to do his job. Or at least to add some stuff. They can do so if claims is there unless somebody avoid making or at least, allowing them to make a claim for it. They may not notice that it's some material fraud or forgery or anything. They may not see a difference in none of that. They might not notice that the amount spot is open and somebody else could do it. They may want to do it themselves. Or they may not notice it at all and just pay equal the amount for it.
As a choice of law.
Yeah.
I know we probably covered this, but if let's say you're still mailing and you sent in a proper letter of credit and they dishonor it, what recourse or enforcement channels would you suggest?
How do you know you sent in the proper notice? You sent in other documents that needed to go with it?
Well, I looked, I listened to last year's UCC 5, and it talked about a bunch of those things. So if we get there, I would love to ask some questions about the money order or a handwritten letter of credit, but I didn't want to I wanted to stay present.
Dang, they talked about that in Article 4A and 4. They already talked about that.
Right.
That's how we create or get to the point of having letters of credit. They talked about it. You should have asked there, but something didn't click with you. I wonder what it was.
Well, no, it did, but what it was is I actually didn't know about 4A, so I listened to 5 early, so I had it there. Okay. Yeah, so it threw me off. So, yeah, but no, it was just my issue with the letter of credit is what you're talking about is I can't identify on the notice whether or not they're saying to include an additional document or not. That is still unclear to me there.
So you wouldn't have to include an additional document. As it is given to them upon your request and them having the burden of approving the amount, an additional document is going to be given to cover those damages. In Houston, when I showed y'all, we got you covered page. Yes, that was a document that they created. I didn't create that document. They created that document because they had me covered. That document had to go along with all my statements. You can't create that. They got to do that part.
So is that like Capital One has an application for letter of credit?
Say it one more time.
Capital One has an application for a letter of credit. Would that be equivalent?
I actually would say they all kind of do. Oh. But it just depends on the claim for it because it's given to you in the public. So it just depends on the type of claim that you're making when it comes to a letter of credit. You have the burden of establishing facts. Your burden of establishing facts with another person allows for the issuer to have the burden of proving the amount. What amount is they proving? The amount of damages for it's not being there in the first place, for the issuer not taking that type of action. So whatever needs to go along and accompany the document either be there. Anytime, just like the guy on my live, when you mail it in and it ain't accompanying the documents that's needed and you send it to where you think it should go, but it don't got all of the company documents, then they get a chance to avoid damages because you ain't sending with everything that it needed because you read where you said it should come here and you felt like you should send it there when the agreement ain't between you.
Right. And you just said something that I really caught this time. You said you have to establish fact. You didn't put no S on it. I think myself and probably a few other ones, we try to go over 6 facts in one on one letter.
And really the fact is, it's just some discrepancies. They just said it.
Right.
That's the fact. That's the same fact that's needed to establish the burden of them putting the amount there. Because the discrepancy is it ain't there. Without me even saying the amount ain't there. I don't have to say that. They'll find the discrepancy. They'll see it apparently on the face of the document. I don't have to say apparent on his face or none of that. They'll see it with their eyes. And then they have intellect and knowledge about the action that needs to be taken to avoid further damage for something that belongs to theirs. How you feel? What you thinking? Aaron, what's up? With an E or A.
I'm here, but I kind of missed that part because my service was going in and out.
That's okay. I'll remember. How you feel, Shelby?
I feel good. It's a lot of clarity. And there's one little part that I would like to get clarity on when it may not be now, but whenever on my American Express, they've got 4 different people across the top there.
Okay.
And I have a little, when I think I got it, I hear Jared or Aaron speak on it, then you reply and it throws me off.
Okay.
So
no, come on, you can talk about it.
Okay. Well, for instance, I'm looking at one right now. I have American Express logo. Right next to that, I have Platinum card, and on another card is Business Platinum card. Directly under that, it's got my name, and on the business one, it's got my business name. Obviously, the personal has just got my personal. Then it's got closing date and account ending, and on the left side, it's got on the personal a Platinum card image. So we have American Express.
And all of the cards and things that they have rights to already, state and federally, which is the Platinum card, your business, that name, they have all of the rights. They have companies within them. They have members, affiliates, associates that help them process it in the sequence. They do it all. They have rights reserved to it right along with you. They just don't have the obligation or rights to issue it in another way until you request it. They'll make a claim about it because they'll consider the fact that you want to determine or a determination for proving the amount of damages. That's what they'll take it as.
And I would really refer that to Platinum card with their trademark because they have rights.
Yeah. And those same rights that they share obligation. American Express, you got the plastic Platinum card. They're going to use that Platinum card, the paper one. So same right, just like how this issuer is switching in 2 different transactions, that's the exact same thing that's happening. And each person's name is signed on it. It's just the fact that their signature is forged because they ain't have no authority to do it because they're not the issuer of it for this new transaction. Somebody else has to be the issuer of it for a new transaction. So it's wrongful for the issuer to dishonor it without the signature already on the draft. This is why it goes back to the issuer because they made a mistake. It wasn't determined at that time. During that duration, it wasn't determined that you would consider other factors. So they made a mistake. It caused error in the payment. So it couldn't have been treated in financing as a financial instrument, but instead as a negotiable instrument to get payment.
Excellent. Good. That's a lot clearer.
Go to the flip over your bill.
Okay.
See important account information.
They put that on the front.
Okay, so maybe you got to look on page like it's American Express, so you might got to look on like page 4 or 5 or something like that. They'll have like a box, or even just look in the heading that may be surrounding the whole document. Somewhere on there, they should speak about federally insured, federally licensed. They should speak about reserve. They should speak about things like that because you are directly dealing with American Express, and they are government mandated.
Okay,
I'll post on my story. I'll find it for you.
Okay, yeah, because I don't like to hold people up when I get nervous when I'm filling paperwork.
I got you. So the issuer, or if an issuer wrongfully dishonor a draft or demand presented under a letter of credit or a demand, I should have said a demand, or demand presented under a letter of credit or honors a draft or demands in breach of its, not in breach of yours, but in breach of its obligation to the applicant, the person who assigned them the document, the applicant may recover damages resulting from the breach, including incidental but not consequential damages, less amount saved as a result of the breach. So whenever they're dealing with breach and they know it is a breach, they go ahead and put in information that results in incidental or damages that they know that they can recover at that time. They don't include consequential damages until you're consequentially included, meaning that you wrongfully have a document that should have been honored by the issuer to begin with. This is why they talked about in Article 2, people going to court when the seller was answerable over it from the beginning. So if ever you get a notice from the seller, you need to send it back to the seller. Remember them saying that in Article 2? I
Yeah,
know it's far back, but you remember it?
that's because I was watching it the other day.
Just want to recover the exact same thing for damages in two different cases. One in incidental case, one in consequential case, and the person who finally has it all will have all of the documents that they need to prove both cases. Once they have all that they need to prove both cases and have any and all documents that's needed for that case, then they have established the burden of proving the amount. After they get that, we got you covered page. That's the insurance page. That's for the claimant who has made a claim. If an advisor or nominated person, other than a confirmer, breaches an obligation under this article, or an issuer breaches an obligation not covered in subsection A or B, a person to whom the obligation is owed may recover damages resulting from the breach. So as a result from that breach, the person who you're in business with will be able to recover damages for both of y'all. So both of y'all are discharged. That's upon termination, something that was in a less amount. To the extent of the confirmation, to the extent of the person who's actually doing the confirmation, a confirmer has the liability of an issuer specified in this subsection and in subsections A and B. So the confirmer and the issuer are going to be switching positions in specified situations, in specified cases where they're dealing with breach. The issuer will become a confirmer of that breach. And whatever amount is owed, they're obligated to recover it because it should have been there automatically. So the titles keep switching so that the bottom line is in this circle, in this circulation, and this flow, nobody actually really pays. We just use the same documents to cover each other and circulate it, and whatever somebody didn't do, we keep doing it so it's complete. The liability really ain't gonna be on nobody. How y'all feel? This is less an amount you give, save them from the result of a breach. But the result of a breach is everybody covered. And they give the result to the breach because they're going to be the ones to recognize the damages. They're going to have the claim for the damages with the issuer. The issuer is the reason why they got the statement to begin with. And that same issuer is the one who's going to give them advice on what to do about this mistaken or potential error. You just help them make that request.
This is after it was accepted, right?
Exactly. Yeah, they still talking about after. And then before they were talking about the wrongful that was here. That's why they had the if, because they was referring to our draft and a letter of credit. An issuer, a nominated person, or an advisor who was found liable under sections A, B, and C shall pay interest on the amount owed. So when everybody is presenting stuff and they getting their interest and it's being transferred, it's because they realize, okay, it was an amount owed. It was an amount of interest owed there under. It wasn't paid. Okay. So from the date of the wrongful dishonor or other appropriate date, they add it back. So that's what they talk about, add an interest. They gonna add the interest. We just have to be interested in them conducting a transaction where they actually pay interest. Otherwise, they're gonna take your interest because liability of them to pay it has not yet been found or discovered. Reasonable attorneys' fees, reasonable representative fees, and other expenses of litigation must be awarded to the prevailing party in an action in which a remedy is sought under this action. Under this action, you're not going to sought or seek any remedy. Under this action or under this article, you're going to determine your rights. That's the action that you're going to take. And that action is prevailing for a party of the actual agreement to be awarded remedy, meaning that they'll arbitrate, litigate, mediate over the document with a representative on the appropriate date that that type of transaction actually happens and wrongful dishonor has actually been determined for the amount of interest that is owed. Damages that would otherwise be payable by a party for breach of an obligation under this article may be liquidated. It may be added by the agreement or undertaking. So whatever you saw that they promised to do that they didn't do, whatever the agreement says should be added but wasn't added, the other party, that's the one who's going to add it. But only in an amount. So only in numbers. So if you fill in that spot for them and it ain't right, then it's wrong. They have the formula or you may know of a formula because it was reasonably in light of harm that was anticipated on your bill through a testing field. It's to help measure the amount of damages potentially for any other person who can liquidate that account and be awarded that account through remedy, other actions legally for the amount. How y'all feel? What's your thoughts?
Are they saying it's a notice of claim even if the document is damaged?
It is, because now they're gonna have to claim that it is actually damaged. Now it is actually damaged.
Right.
And it's damaged by the representative. It's damaged by the person who was trying to put fees in there or add up any other expense that somebody else could have litigated over or judged commercially, like the testing field.
Right, because now they can recover from that.
Exactly. Or they give you the opportunity to liquidate the agreement again and undertake again. Got options. It can be done by an amount that they determine or a formula that they determine and that they show you. If you know how to do it, you can do it. But in light and information, something's missing. And it's harmful against the seller. And it is impacting what can happen in the future. So they are anticipating rejecting and correcting any past mistakes or potential error, especially if they put you on notice about it. They're waiting for the request of what's mistaken and what could be done and what do they need. So remedy is sought, not by you, by them. You have the rights to see that they seek remedy on your behalf. Transfer of a letter of credit or do it. How y'all feel? Transfer that letter of credit and using it according to applicable law that would violate. They telling you off top they violate you. Applicable law applies immediately. That transfer or that transferee failed to comply with requirements of the document and what it's relating to and how it should be used and what's actually imposed on the issuer. They dealt with standard practice. It should be referred to other circumstances that is reasonable under Article 5, where that merchant decides to actually have good faith. Because someone knows transfer a letter of credit by operations of law and not legally. Any questions? Any thoughts? How y'all feel? Look, I ain't trying to keep y'all here too long. I mean, it's pretty much what it is, but how y'all feel?
I think this is the section I was reading yesterday where I was like, oh, nope, let me go on and go back.
They're talking about a lot of stuff in here because they're talking about the successor of a beneficiary. So someone who was successfully dealing with a beneficiary or accepted that title of a beneficiary due to law. A successor of a beneficiary may consent to amendments. They may sign, may present documents, and receive payment or other items of value in the same or in the name of the beneficiary without disclosing its status as a successor. So a lot of people or individuals believe they are a beneficiary, but somebody else is the successor and having the status of a beneficiary, not you. That other person has other documents to present. They have all the documents that they sign and can amend in the sense of doing so for as long as whenever payment is received, another person is making a request that the item, or at least letting another person know that the item is of value for whoever the beneficiary is. But they're letting you know right now that they're held out. The beneficiary is the one who's going to benefit, who's going to be the successor. The successor is going to be the one who signs. The successor of a beneficiary should be their bank. The successor, it should be the beneficiary's bank or even the beneficiary themselves. But you can do it if you would like. They give you options in light of the information that could and would be done. How y'all feel?
Okay. When you say it like that, it sounds different than how I read it. But this literally brings me to the controllable electronic record. And again, having possession
Oh, yes.
and exclusive benefits.
They have the ATM machine that your document concerns. That's why I say you not, you know what I'm saying? That benefit is not, that beneficiary for real is not disclosed. That's why the payment networks is going to help. Because they're not disclosed.
For the successor.
What did you say?
I was thinking the payment network was the successor.
But they successor of a beneficiary. It's not staying with either one of them. It's going to the beneficiary's bank.
Right.
They were successful in disclosing information that was needed for the beneficiary to receive payment or to receive an item of value. They already received payment, so we kind of off of it.